My name's Jack Nolan, and the purpose of this video is to give you information that will help you with your workers' compensation case. I spent 22 years as a workers' compensation judge, and I've now been practicing for 7 years, representing people who have been injured at work. When I decided to retire as a workers' compensation judge back in 2008, all I wanted to do was workers' comp. That's all I had done for 22 years. And I had to decide, do I want to represent employees or do I want to represent employers? I decided to represent employees. And the main reason was because there were plenty of good attorneys on the employer-insurer side, but there were very few attorneys on the employee side who really limited their practice to workers' comp and knew it well enough to do a good job. I felt there was a real need for employees to have an attorney in this area who would just do workers' comp, knew the law, knew the attorneys, knew the judges, and could do a good job of protecting their interest. And it's worked out fantastic. I think that was a good choice. I enjoy what I'm doing, and so far we've been very successful. And there are certain things that you need to know if you have a work-related injury. I'm going to give you a little information first about workers' comp in general. Prior to workers' compensation, there were no benefits. If an employee got hurt at work, the employer didn't have any obligation to provide medical treatment, didn't have any obligation to pay them workers' comp while they were off work, and there were no permanent disability benefits. The employee's only remedy was to go to court, prove that the employer was negligent, and file a lawsuit. That was not a good system. Most people didn't get any benefits, and so back in the 1930s, they passed the Workers' Compensation Act in Missouri, and it was designed to help injured employees. But it was a compromise between employees and employers tend to forget this. In return for these limited benefits that are available under workers' compensation, employees gave up their right to sue. Workers' compensation is your only remedy. You cannot sue your employer if it's a covered employer and a covered employee. Your only remedy is under workers' compensation. And employers tend to forget that when they complain about their workers' comp premiums. Some employers, unfortunately, treat employees as if they've done something wrong when they have a work-related injury. They put pressure on them not to report it or not to get medical treatment, and that can cause serious problems emotionally for an employee. You need to understand that that's the law. If you have a real injury, it's a work-related injury, you're entitled to those benefits, and you need to report it, and you need to go ahead and take advantage of those benefits and not worry about the consequences. Your focus should be on getting fixed, getting well, getting back to work. And if you do that under the workers' comp system, you're going to be fine. When an employee is injured, the first thing they should do, regardless of the pressure from your supervisors or your coworkers or your feelings that it might have a negative impact on your job, the first thing you should do is report it to the appropriate supervisor or human resource officer and ask them to fill out an accident report, an incident report, because if you don't do that, you may be giving up your right to benefits later on. Report it. If it turns out you don't need treatment, fine, but make sure you report it. Then they have an obligation to turn that in to the insurance company, who in turn reports it to the Vision, and they're supposed to do that within 30 days. So that's very important that you report every accident, every injury, even if you are hoping it'll get better over time, because sometimes it doesn't. And if you don't report it, then you can lose your rights to benefits because you have a legal obligation to report it within 30 days after the date of the injury and in writing. The benefits under workers' compensation are automatic to some extent. You don't have to prove that your employer was negligent. Your burden of proof is very simple. You have to prove that you had an accident or an occupational disease that it arose out of and in the course of your employment, and you have to prove that that accident or that occupational exposure was the prevailing factor in causing your injury or medical condition. If you can satisfy that burden of proof, there are 3 benefits that are normally available plus a couple of others. The main ones are the medical treatment, temporary total disability, and permanent disability in some cases. There are also benefits for death benefits if an employee is injured and as a result of that injury passes away. So you have these limited benefits. I'm going to give you a little more information about those right now. The medical is probably the best, and yet it's the most frustrating. It's the best because there's no copay, no deductible, and really no time limit, and the scope is very broad. The statute says that the employer is responsible for providing all the medical treatment reasonably required to cure and relieve the employee from the effects of the injury. That's all good. The time limit, there is no time limit except once you settle your case, that's it, your file is closed. So the insurance companies tend to want to rush you through, get your case settled quickly so the file is closed. I recommend that employees wait until they're pretty sure they don't need more medical treatment before they settle their case. There's also a 2-year statute of limitations. If you don't file a claim within 2 years after the date of the accident or the last benefit provided, then you're barred from filing that claim. So you have to keep that in mind. But the medical can also be, it is the most frustrating and usually the most problematic. And the reason for that is under the Missouri statute, the employer has the right to select and approve the treating physician. The statute says that you, the employee, have the right to go to your own doctor at your own expense. The problem is most people can't afford that, and their insurance policies usually exclude work-related conditions, so that's not a very good solution. So that gives the employer tremendous power. They have the power to pick the doctors, and they also have the power to control the purse strings. There are some abuses of that. It's very common in workers' compensation. There's 2 parts to that. First, the doctors and healthcare providers want to do workers' comp. It pays very well. So we call them company doctors. The doctors want that business. They line up to get that business, and they want to get the referrals the next time and the next time. So what does that mean? It means that they lean in the direction of the employer on the tough issues. Is it a work-related injury? How long should you be off work? How much permanent partial disability do you have? All those issues, should you have surgery? There's always some pressure on the company doctors to lean in the employer's direction, and that can be a problem. The other part of that negative situation is that the statute says the employers are supposed to be able to pick the doctor. It doesn't say that they can control the treatment, but they use the power of the purse to do that. Doctors want to get paid, physical therapists want to get paid, the radiology people want to get paid, so they won't do anything unless the insurance company authorizes it, and that can cause delays, it can cause problems. A doctor may recommend 10 weeks of physical therapy and the adjuster will only approve 4. That's not supposed to happen, but it does, and a lot of our clients come to us because they're unhappy with the medical treatment that they're getting. I will tell you that there's a conception in the general public that people who have work-related injuries are just out there to get the money. I can tell you that based on all of my experience, that's not true. 95% of the employees that get hurt, all they want to do is get fixed, get well, go back to work and have a normal life again, and that doesn't always happen, and sometimes it's because of the employer insurers abusing their right to pick the doctors. I think over half of the clients that we get come to us because they're frustrated over the medical treatment they're getting, they don't have any control over it, and we try to help them navigate that minefield so that they get good treatment and have a good result. That's in everybody's best interest, and we're very good at doing that. When you get past medical, there's temporary total disability benefits. The statute says that if you miss work because of your injury, if a doctor takes you off work, the first 3 days are free. After that, they're supposed to pay you 2/3 of your average weekly wage while you're off. They look at the 13 weeks before the accident and take an average, and then they pay you that. It's called temporary total disability, meaning that you're totally disabled, but it's temporary. And after 2 weeks, they're supposed to go back and make up the first 3 days. Sometimes that goes well, sometimes there's problems with that. We like to check the rate, make sure they're calculating the rate of compensation correctly. We want to make sure that they give you all the benefits that you're entitled to, including the temporary total disability benefits. We see a lot of problems with light duty or restricted duty. The insurance companies pressure the doctors to release you on restricted duty or light duty because they don't want to be paying you the temporary total disability. They pressure the employers to do that by telling them that if you offer light duty, your premiums won't go up. And that's great, you get a full paycheck, but sometimes problems arise where they're asking you to do things too soon, too much, and it makes your injury worse. And a lot of times employees have to come to us to get help with that. We work with the employers, the employees, and the doctors to try to make those restrictions reasonable. And I can tell you there is a trap there, because the statute says if you get terminated for post-injury misconduct, which means misconduct after the date of injury, they don't have to pay you temporary total disability benefits. I think that's a bad law. It's there, but if your employer offers you light duty and you refuse it and they terminate you, we're in trouble because we may not be able to recover those temporary total disability benefits. So you have to be careful in that situation and not refuse light duty. The third benefit is permanent partial disability. It's usually the last thing on people's mind when they come in to see us. They just want to get through the treatment and have a good result. But in the end, if they have an injury or they have some residual limitations and symptoms, anything that has surgery is probably going to fit that category, and it's called permanent partial disability. There are a few cases where people are hurt so bad and have such a poor result that they can't go back to work. That's called permanent total disability. But the permanent partial disability is based on a chart that tells you how much each body part is worth. If I have my hand amputated at a sawmill, I get 175 weeks of compensation. If it's the elbow, it's 210, shoulder 232. If it's body as a whole, they rate it as a percentage of 400 weeks. So the formula is, for a carpal tunnel syndrome, for example, a judge is going to say, if you have a 10% disability, that's 17.5 weeks. I multiply times that times your rate, and that's how much money you get. It's a math formula. It doesn't matter whether you're 20 years old or 60 years old. The body parts are worth the same. The main variable is the percentage. From the employee's perspective, I will tell you the problem is that the doctors use orthopedic or AMA guides to rating. They're always way low. They're lower than what the judges are going to give you. The insurance companies don't tell you that, and you have no way of knowing how much that case is worth. So that in my opinion, the employees need help from an attorney who knows what he's doing to get a reasonable settlement on the permanent partial disability and the other benefits that haven't been paid. One of the reasons I say that is because we used to have legal advisors at the division. They were there from when I started in 1986 until 2006, 2 years before I retired. And those legal advisors were there to help employees who didn't have attorneys. The employer-insurer side resented that because they thought they were having to pay a lot more than their doctor's ratings, and when they got a chance to amend the statute, they did in 2005. It went into effect in 2006. The legal advisor position was done away with, and the judges were told, okay, you're a judge under ethical standards. You can't be their attorney. You can't give them legal advice. You can't even tell them what you think their case is worth unless both sides agree, and then they won't always agree to let the judge do that. So there's not much help from the judges. The only thing they can do is if they think if they think you need to see an attorney, they can recommend you talk to an attorney. If they think the settlement is so low that it's maybe even less than half of what it should be, the judge will say, I'm not going to approve that settlement unless you go talk to an attorney. But there's not much help there in the division anymore, and there's been a study done by Lawyers Weekly which shows that the value of settlements for pro se employees after that statute was passed dropped by anywhere from a third to 50%. So from my perspective, in most cases, you cannot get a fair or reasonable settlement if you don't have an attorney, and it needs to be an attorney who tends to specialize or limit their practice to workers' compensation benefits. There's lots of reasons why people should consider getting an attorney. That getting those benefits is the main one, but there are also other issues that come up. Social Security disability. If you don't have help, you may have money coming in to one hand from workers' comp, and you may be losing it on your Social Security disability check. We can help avoid or minimize that offset if you have an attorney who knows what they're doing. There's also issues with Medicare, future medical. You may have an injury where you're going to need medical treatment for the rest of your life. The insurance companies aren't going to tell you that. They're going to try to get your case settled and get it closed. But you have to be careful, because if you end up on Medicare, either because you're on Social Security disability or you hit age 65, they may refuse to pay those bills if you didn't protect their interest when you settled a workers' compensation case. That can be a serious problem, and we have spent a lot of time learning how to protect employees from losing potential Medicare benefits. One more thing I'm going to add, and that is that if you try to do this by yourself, that's fine, but you have to understand something. The insurance company has adjusters, nurse case managers, and attorneys, and they're not working for you. They're working for that insurance company. They can't give you advice. The attorneys have a client, and it's not you, and it would be a conflict of interest for them to give you advice on your workers' compensation case. You're going it alone against people who do this for a living, and their job is to get your case settled as quickly as possible, minimal amount of treatment, and for as little money as possible. And in this world today, in the current situation in Missouri, I recommend that every employee that has a serious injury that requires medical treatment talk to an attorney who knows what they're doing as soon as possible to avoid mistakes and to get good treatment and to get a reasonable settlement. Thank you.